Please be seated. Good morning. This third case is Jeffrey Charles versus the Nevada State Contractors Board, case 62101. Mr. Corey?
Thank you very much, Your Honor.
Ready to go?
I'm ready to go. Court, please.
Okay, please proceed. Thank you.
Your Honor, this is an interesting case from a lot of aspects, and I just respectfully thank the court for giving us the opportunity of oral argument, because sometimes when you tell a story in paper, you sort of feel that you just didn't really get the job of kind of fleshing it out. What's interesting about this court, Your Honors, is the fact the statute is very unique, because the statute we're dealing with is a subsection of NRS 624. And the essence of the statute that we're talking about here is a very restrictive procedure through which people that have been damaged by contractors can recover from a fund that is actually funded by contractors contributing through licensing fees to the fund. As a result of that, the structure of this particular recovery fund is very unique because it has some very untraditional things. For example, a section of the statute talks about the notion that when you go to the board, if you don't like what the board does, there's actually a provision under 624.510 that says you can't seek judicial review, that that's the end of it. What's interesting about this case is that we stand before you on an issue that we contend is a matter of law, not arbitrary, capricious standard, but just a legal standard. Well, my client's contention before Your Honors is this, that there's a provision of the statute which is found at 624.490 dealing with satisfaction of judgments. In essence, my client's contention is that that is available to a person who seeks relief from the recovery board when the normal procedures that you would follow going through the recovery board's hearing and hearing process don't work for you. What the record in this case shows is a very unique series of steps. Mr. Charles first made a complaint to the recovery board, and they said, no, we're not going to deal with it. We don't think it applies to you. He then went ahead and filed his own lawsuit, essentially did a writ, and while the writ was pending, the board went ahead and said, okay, we're going to give you a hearing on this. In the meantime, it was very unique circumstances. They noticed the hearing, but didn't send him a notice of it. They acted. Then he's back in court again asserting that he wants to have his hearing. There's actually a proceeding, which is part of our record, where nothing really happens because there really wasn't anything to do. He eventually gets his hearing. He employs an attorney for the first time, hopefully that would help him, me. And we go through the steps of going through a hearing. Now, while all of the issues that I'm talking about have transpired, in essence, Mr. Charles goes out and gets a judgment against the responsible contractor that caused him some damages. Ultimately, we have a hearing, and the board...
Did he, in fact, get a judgment against the contractor or the person who hired the contractor?
He got a judgment against the contractor that ultimately went defunct. It was Flowcore. And Flowcore was determined to be a covered contractor, and the bad act, Justice Douglas, that was involved there was essentially that the contractor, having been retained by him, when he filed a lien on his property, he ultimately suffered some substantial damages and went through a complete arbitration process. In fact, the arbitrator, at our request before the trial court, actually gave us a basis of opinion so we could supplement our record to establish the damages. Now, ultimately what happened, which was very interesting before Judge Bell, and I refer the court to these kind of critical parts of the record. On the appellate's appendix, at page 168, we have Judge Bell's decision denying the relief that we sought, which is the basis of our appeal. And at lines 13 through 21, she determines for the first time that Mr. Charles is not an injured person under NRS 624.420. We were troubled by that and raised it in our appeal because that was the first time in the administrative process that anybody raised the issue of him being an injured person. The board didn't raise it. We believed it wasn't even an issue, and in the judge's minutes, when she first made her, I call it a minute, or it's sort of tentative, for lack of a better term, at the administrative, at our appellate record, appendix at 178 through 179, Judge Bell notes that there was never even an issue as to whether or not Mr. Charles was an injured person, but ultimately she found he wasn't. The key to her decision, which we suggest deals with a legal interpretation of 624, comes in the notion that she actually cites that the board's determination that Charles wasn't eligible to receive a payment was that he didn't follow the board's procedure, which was normally he had to pay for the lien and then seek reimbursement. Now, my suggestion, respectful suggestion, Your Honors, is this. If the board's interpretation of the law is correct, essentially it just guts a major portion of 624, which is 624.490, which is entitled satisfaction of judgments. Because you don't need it. You never get there. You would never get there. There would never be a basis to do anything dealing with satisfaction of judgments. Our respectful suggestion to Your Honors is this, that the board has basically tried to rewrite the law, and if they want to do that, they need to go to the legislature. So we respectfully suggest to Your Honors that if you look at 624.490, the reason that it is there is when the board system either breaks down, or it's not timely, or it's another mechanism you have to go into the legal system to get the relief you need, then we go back to the board. Now, here's the safety factor that's part of the statute for the board. The board says, hey, we have limited funds. We don't want to pay out an improvement judgment. We don't know what's going to happen over here in the trial court. Our safety factor comes into two places. Number one, we look to see if the person qualifies as an injured party, which according to the statutory definition of injured party, there's no doubt that Mr. Charles would, but secondary to that, there's a limitation on what the payouts are. And the board can only pay what funds it has available. It makes a decision. The board can't pay more money than it has. And the provisions basically protect the board so that there's not a runaway trial court. Now, the also unusual aspects of the law, Your Honors, which kind of gets bounced around a little bit, which makes it a really interesting statute, but there's a provision down in 624.510, it's paragraph 8. You have a chance to take a look at that. It talks about the notion that when you seek damages for claims somehow or another that exist under the statute, after the statute says you have no right to judicial review, that the only way you get attorney fees in that proceeding before the Contractors Board, I presume it's for this proceeding in front of the board because the statute's been unclear, is that the case goes to the Supreme Court. So you have a statute that says you don't have judicial review, but if you do get some type of review, you get your attorney fees. Now, Judge Bell pointed out there's a bit of an inconsistency in auditing to that point in the statute. And I just respectfully suggest to the court what we're really dealing with here is the notion that we have the legislature that had a piece of legislation that sort of had some things that kind of tangled up a little bit. May not have made sense, but in the overall scope of what we're looking at, it's pretty clear that there was a provision that was available to seek a satisfaction of judgment from the court of proper jurisdiction. And I just respectfully suggest, Your Honors, that our record before you establishes that the damages that were talked about here by Mr. Charles related to a malfeasance of a contractor. We established what the damages were as in terms of being an injured party. The limitations of the payout are set by the statute. And at that point in time, once the Contractors Board says, hey, we're going to make you come in and relitigate, it makes that provision of the statute just nonsensical. There just wouldn't be a reason for it. Judge Bell really grasps that in her decision because she basically says that under their procedure at the appellate's appendix 168, which is her decision, that she's saying what the board says is here's what you have to do in order to have a claim with the board. And again, we respectfully suggest that that's just a misapplication of the law because otherwise the provisions of 624.490 just don't make sense. I'd like to add more to my argument for you, but I just think that's it. It's very straightforward. I'd be happy to answer any questions. I will reserve a little bit of time to respond. But again, I thank you. I also want to apologize. We're running a little bit late. I had a medical appointment, so I came back to Nevada early this morning. When I called, I didn't realize the calendar was being moved up.
Well, I hope we didn't inconvenience you to make your argument here today, timing-wise.
No, I'm fine, Your Honor. Thank you.
You have some additional time. If there's other points you'd like to make, do my colleagues have any questions?
No. I think that covers everything, Your Honor. Okay. Because other than we have a chance to do rebuttal.
Okay, well, you'll have a chance to hear Mr. Ling and I'm sure that will inspire you to make some further remarks.
Thank you, Judge.
Okay. Mr. May, are you ready to inspire your opponent?
I'll do my best. Thank you. Good morning, Justice Hardesty, Justice Cherry, Justice Douglas. My name is Louis Lane. I am counsel for the Nevada State Contractors Board. Excuse me. I guess we are here today on a writ. Our basic argument has 2 points. The first point is that as a writ, they must prove to you, just as they needed to prove to Judge Bell, that they have no plain, speedy, and adequate remedy at law. The way this case is framed is actually the opposite. They do have a plain, speedy, and adequate remedy at law. As they showed you over and over, and it's in the record, he has a judgment against the contractor for $53,000. He can go pursue that judgment any way he desires. The judgment exists. The record actually shows what happened in this case is Mr. Charles got the judgment for $53,000. He, as far as we know, has never actually tried to pursue that judgment. Instead, 4 or 5 days later, he comes to us and files his judgment with the Contractors Board, and then now, here we are, all these years later, he is still asking the Contractors Board to cut him a check for $35,000 under the statutory scheme that we're going to be discussing today. So our first point is simply that he does have a plain, speedy, and adequate remedy at law. We've cited to you the Washington County Commissioner's case versus City of Reno, which says that you don't judge the adequacy of that remedy by whether you're going to actually get money. You judge it by, does the process produce something by which you can legally pursue your rights? That already has happened here. The second point then is to get into talking about our statutory scheme. In 1999, when the Residential Recovery Fund was created, it was created as one section of our statute. You'll actually see in the NRS, it's this separate section within Chapter 624 that is essentially self-contained. And that's important for the resolution of this particular matter because contained within that is all the definitions you need. We don't need to go out to look for common law definitions of the various terms that are used. The legislature actually defined absolutely all the terms that we're going to be discussing today. And we, the board, are of course constrained by that statutory system. Our job is to implement the system that was given to us by the legislature, and that means we have to follow the system they gave us. We have to therefore follow the definitions they gave us, and we have to take the statutes as they are actually written and apply them to the facts that are given to us. In this particular case, let me back up. The statutory scheme is very simple, actually. To get in the door and get paid, you have to be an injured party, and that term is defined by statute, and you have to have an actual damages, which is also defined by statute. And so to get in the door, you have to first be an injured party. There are 2 ways to be an injured party. You either have to have a ruling that the contractor that's involved with you has violated some provision of the Chapter 624, or you have to have paid the lien if there's a lien involved. And there's a bunch of more qualifications as to what the lien has to be, etc., but that's not really an issue today. What's an issue today is you either have had some finding somewhere that the state's contracting laws have been violated, or you paid the lien. The reason for that, and because those are the only 2 ways you get in, that's the only 2 ways you can be an injured party. If you think about the structure of this, what this is intended to do is to create a remedy for homeowners who have been harmed by this contractors that is quick, that is non-adversarial. The proceedings in this case, for example, point that out. There are no attorneys representing the state in the proceedings. We have an investigator. The investigator presents his findings. And it's supposed to be a quick resolution of these matters so that everybody gets paid that needs to get paid. And that's why the second thing, which has troubled Mr. Charles, that's why the second provision of how you get in the door exists. Because if you have a lien problem, you pay the lien. Now whoever has not been paid, they get paid. And now you come to the Residential Recovery Fund, and you can now apply very simply and get your recovery from the Residential Recovery Fund. Mr. Charles didn't choose to do either of those two options, and he wasn't wrong to pursue the option he did pursue. The problem is not that he didn't choose a perfectly reasonable way to approach his lien. He was angry that he had been liened by an unknown subcontractor to him. He has every right to be angry about that. He was wrong, and it is in the record that when the sale was having problems, he was actually told back in 2006 that we can clear all this up if you just pay the lien, get the lien off the property, and we can go forward with the mortgage, and that's in the record. He didn't choose to do that. He chose to litigate. Okay, you can litigate that, and that's a perfectly acceptable way to handle this. Unfortunately, what resulted in this case is he had several cases. They went forward, and when he was asked in the final of his cases what his damages were, the subject of the judgment in this case, he spelled it out himself to the arbitrator. His damages were all attorney's fees. He was attorney's fees for the various cases that he had pursued to get to that point. He's always been honest about that. He said that in the arbitrator's brief, and subsequently when we grant him a hearing, and we're getting ready for hearing, 2 weeks before hearing, Mr. Corey submits a letter containing the exact same description of what the damages were that he was seeking. The damages were attorney's fees for pursuing the case. And that gets us to, I suppose, the real nub of the issue. Mr. Corey has argued in his briefing that we are nothing more than a cipher. You go out and get a judgment, the case happens to be called individual versus contractor, and the board doesn't get to look beyond that. You just simply, we're an ATM. We at that point pay out $35,000 or whatever you claim. And that's not the law, okay? And that can't be the law. The law under 624.510, and I want to cut to this because this, I think, explains really the essence of the whole argument. If you want, 624.510 is the section by which we are going to cut a check to a claimant under the Residential Recovery Fund. What does the board need to have if we're going to write that check? The legislature has told us that if we're going to write that check, this is subsection 3 of 624.510. It says, if the board or its designee determines that an injured person, so that's actually in the statute, is eligible for recovery from the account pursuant to this section or NRS 624.490, the section that Mr. Corey is referring to, the board or its designee may pay out from the account, and you go down to subsection B, which is the one dealing with 490. The judgment was obtained as set forth in 624.490, the amount of actual damages. So, if we're getting ready to cut this check, we have to make those, somebody has to make those judgments. Was the person an injured party? Do they have actual damages? As I've explained, the definition of injured party, injured person, is 624.420. There are those two ways to get in the door with us. He was not either one of those.
Mr. Lang, I don't see in the Contractors Board's decision that it was rejecting his claim on the basis that he wasn't an injured person. Am I missing something?
No, that was not argued or presented either way to the committee when they were reviewing this. They were looking, as you look at their report, their decision was based on the issue of actual damages. Either one would disqualify you.
But if they didn't reject him on that basis, wouldn't we ordinarily assume that that's been waived for further discussion, and you focus on the reason that they did reject him?
No. The way this case was framed this was a writ that they were seeking. The obligation is always on them to prove that they were qualified under this statutory schema to be paid. And so we were arguing that they were not qualified.
I guess I'm a little bit curious about whether we should entertain the writ or whether the judge should have entertained the writ against a statute that specifically prohibits judicial review of this committee's determinations. Take, for example, an administrative agency's determination, the State Board of Equalization, by way of an example. And that statutory scheme, hypothetically, says no judicial review. Don't the courts evaluate whether the statute can prohibit review based upon whether there's a property interest involved or a liberty interest involved, and then make the assessment about whether there should be any entertaining of the writ or petition for judicial review? I mean, counsel here seem focused on the elements of a writ, but it would seem to me that in a statute that prohibits judicial review, period, I don't know how you get to the court system by way of a petition for judicial review or a writ. Does our entertainment of the writ circumvent the prohibition contained in the statute?
Our argument, to answer your question, we had a petition for judicial review in front of Judge Baer. That was the first legal proceeding in this matter, and Judge Baer dismissed it on that very grounds. He looked at the statute and said, I can't do this on petition for judicial review because the legislature said I can't look at this. So he dismissed it. He hinted in his discussion that day that he felt that it might be appropriate to have this matter reviewed as a writ. So Mr. Charles, listening to the judge, came back and filed the writ, which is how we are before you today. We did argue that any kind of judicial review of this panel's action, including a writ, seems to be what the legislature intended, that they did not want courts to be reviewing these decisions, and that fits in with the schema that this is supposed to be a quick, easy way to adjust differences between consumers who have been harmed, homeowners, and contractors.
So in the argument before Judge Bell opposing the writ, you did make the argument the statutory prohibition extends...
Yes.
Right. Yes. But as part of that argument, did you offer any reason beyond the express language in the statute?
No. No, we did not argue that. Well, allow me, I've got 2 minutes, just to sort of illustrate the ultimate...
Let me ask you this additional question procedurally.
Sure.
Could a claimant under this statute seek declaratory relief for an interpretation of the term injured person or actual damage?
That's a good question. I think the legislature's intent in saying that they did not want judicial review of the decisions made by the committee indicates that they had considered this and they did not want there to be a judicial remedy to review that. Again, that's going to be up to the court, as it was with Judge Bell. She decided that she felt that she could go forward with the writ and review the writ, hence her decision and how we got here today.
Mm-hmm.
The question the best way to look at this, as I said, is to look at the end of the statute, the end goal that Mr. Charles is seeking, to see whether he qualifies. And if you look at the statute that we would have to follow, if we were going to cut that check, somebody has to find that he was an injured person and that he had actual damages. He's arguing that's not us. He's saying that it's automatic. He gets a judgment, he gets money. I don't know who else it would be, okay? The legislature entrusted the board with the authority to administer this section. It must be us who would be making that determination. He was not an injured party. He didn't satisfy either of the two definitions of injured party, which is in the statute. So we don't have to worry about what the legislature meant. They told us what they meant. They said an injured person is, and they list out two ways to be an injured person. And then we get to the question of actual damages. What is an actual damage? In this particular case, unlike the Supreme Court case that he has cited in the brief, we actually have a statutory definition. The legislature, if you go from Section 3 in 510 down to Section 8 of 510, you will see, may I proceed? Just to get
Go ahead and finish your thought.
If, on subsection 8 of the very same section where we're going to write in a check, it says, actual damages includes attorney's fees or costs in contested cases appealed to the Supreme Court of this state. The term does not include any other attorney's fees or costs. That's a judgment of the legislature. Judge Bell asked and puzzled her way through that and said, this doesn't make a lot of sense to me, but it is what it says, and I am not allowed to order or to reward attorney's fees as actual damages, because the Supreme Court, or excuse me, the legislature has said so. So we are here today with Mr. Charles having admitted, and he's been honest all along, that the damages he's seeking from the Contractors Board are for his attorney's fees, for pursuing his legal rights. Unfortunately for him, those therefore are not actual damages as defined by the legislature. We cannot cut this check, even if we wanted to cut this check. And we cut these checks all the time. We could not cut the check for Mr. Charles because he is not an injured party and he does not have actual damages. As those terms are
Mr. Lynn, any questions by my colleagues? All right, thank you for your argument. Mr. Klein?
Thank you, Justice Hardesty. Let me just be real succinct and try to respond to these items by items. It's troubling that the board's position is that there is no remedy in the form of a petition for writ of mandate, because I respectfully suggest to your honors that if an agency takes steps to interpret the law as opposed to discharging their ministerial function or participating in an administrative function, that's when we need to have the court take a look at what's happened.
Well, is there anything, though, that prohibits the legislature? I think the more applicable question is whether there's anything that prohibits the legislature from enacting a statute that prohibits judicial review of an agency's enforcement or determination under the statute. Why can't the legislature do that?
Well, I think the legislature can do it, but whether or not the court is in a position to honor such a statute, if the statute is intended to essentially usurp the separation of powers, it indicates that portion of the statute just can't be enforced. By way of example, you could say that I'm going to empower an administrative agency to decide constitutional rights, or decide what's going to happen, or to even legislate, but you certainly couldn't do that beyond the empowerment of what the statute is.
Isn't the distinction whether or not the statutory prohibition against court review impairs someone's liberty interest or their due process rights? Here, you don't maintain a liberty interest in this recovery fund, do you?
From a constitutional viewpoint, if this was a constitutional tort, the property interest we have is a due process right to participate in our government and to have the benefit of having the benefits of what the legislature's provided us. But let me just skip over if I could. It seems like this court has addressed that in Gilman versus State and Red Electric versus DeBogman, because in both of those cases, the issue before the court was, did an administrative body make a decision inconsistent with what the statute was? And when the administrative body went ahead and said, I'm going to interpret the statute and take that away from the courts, the honors said, no, that's not appropriate. They can't do that. Flipping that over, when we take a look at, for example, their argument that Mr. Charles is not an injured party, when we actually take a look at the statute itself, Everything we do talk about the notion that an injured party has to be in the process of this lien satisfaction, payment for something we didn't do, we repay you, but that doesn't even look at the first prong of the statute. If the board says, we interpret this law and we're going to disregard this portion of it, I respectfully suggest, Your Honors, that's why we need you here. I think we need the court to step in and say you can't do that because the statute requires you to apply what we've told you have to do.
This finding that the board did brings it down to one factor only, actual damages. And their position is we applied the law as it's been written as to actual damages. And this is mandamus, so it's either there's a statement as to what that law is, or in the alternative, you're saying they should pay us money. But this is mandamus to compel us to do, the board do one of two things, either follow their law as to actual damages or pay money. So which one is?
But actually, the relief sought here is to direct the board to apply the law, and we're asking the court to tell them via the trial court, here's what you're supposed to do, and you didn't do it because you didn't apply the law. So I respectfully suggest the court, we're not in a position to ask the court to seek a money judgment here, contrary to what counsel sort of suggested. It's to actually direct the administrative agency to comply with the law. And by way of example, I ask a very good question. If we were to take a look at an analysis of actually what happened, the representation is made that somehow or another the board has to reevaluate what happened in the trial court upon which the judgment is being satisfied is sought. The problem with the analysis of the board is the board has said we're going to pick and choose how we determine how we're going to interpret what the arbitration award did. In fact, the trial court was even troubled by that and asked us to get a declaration from the arbitrator, Mr. Payton, who we did, and it appears in the record before Your Honor. Payton makes it absolutely clear the $50,000 award that jurisdictional award he gave to Mr. Charles was for actual damages. The $3,000 component that he directed was for the attorney fees, because that's what he limited what he could award. Now, the underlying record that's before Your Honors is that there were several components to Mr. Charles' losses. He lost a business deal. He had to take steps to essentially redivide his property. There were other things other than just the cost that he incurred of setting the lien aside. But even that aside, the statute that we're talking about talks about the notion that he has actual damages that he incurred that he's seeking a judgment on based upon what had transpired here. I'm troubled by the notion that the board can say, here's this clear language, and we're just going to tell you we're going to redefine it. That's why we're here before you. We respectfully suggest whether our relief is a petition for what a mandate, declaratory relief, or whatever, that we're properly before you seeking relief in the form of asking the board to not reinvent the law when the law says here's what you're supposed to do. Hopefully that makes sense.
Okay, Mr. Clement, any questions? I knew Mr. Lane would inspire you to use the remaining 5 minutes. Thank you, gentlemen, for your arguments here today and your briefing. We appreciate it, and the case will stand submitted.